You know, we talked about this in front of Judge Williams, because in one of my cases, I think the award was $505 million, and he cut it down to, I can't remember what he cut it down to, $330 million. You know, so I lost $170 million in a minute, and I didn't complain, because that's, I felt bad about it. I felt bad, but I didn't complain.
Calling case A 831-169, Christopher Wren versus AffinityLifestyles.com Inc.
So we're handed out the copies of the questions. Figured that might make it a little easier. So number one, and they may not actually be in question format, but rewatch Mr. Morales' testimony, 2 itemized list of exhibits, 3 physical, and somebody might be better at reading handwriting than me, physical something, 5-gal concentrate retail bottle, something real water.
I think it's of, Your Honor.
Yes. Physical of concentrate, retail water, over water. The of.
So on number 2, does anyone, and maybe this is new for the clerk, have an itemized list of exhibits?
So I have the exhibit list that has all the exhibits, but it's not just what was admitted, everything, so that's why they don't get that list.
Any questions? Judge, we can make an itemized list of exhibits.
Yeah, I figured, you know, if you all stipulate, either or both sides could probably do that, I would think.
Yeah.
Rewatch Mr. Morales' testimony. I'm guessing they just want to play it back.
Yeah, Judge, there's a potential issue with that. Mr. Pepperman, unfortunately, was standing right in the way of the camera. So Mr. Morales is the one witness who his face is obstructed. We tried to work around that in our closing by giving different angles. We may not be able to give you a good angle of just Mr. Morales. It's not obstructed.
Shane, it's the artifact judges. Different.
In worst case, we could read it.
But we can play it back, Your Honor. That's not a problem. And I think, as opposed to read it back, I'd rather have it with Mr. Pepperman's head right.
You know, given the wording they use, rewatch, I think that'd be
Right.
even with any obstruction.
Shane, do we know how long that is?
I could find out. What day was it? 4 hours?
Yeah.
Your Honor, question number 3 is, what's the wording between physical and retail?
We think.
5 gallon.
I think it's of.
Everybody but me and you could read it.
It's the left hand.
Everybody says it's of,
Okay. Thank you, Your Honor.
We have a facsimile,
We got the big
picture.
Good.
I thought we have a 5-gallon jug.
We have a demonstrative, Your Honor. I don't mind letting you look at the demonstrative. Or do you have pictures of it?
Dude, I've heard a lot from plaintiffs, anything from defense?
There's nothing too exciting here. I mean, certainly, an itemized list of exhibits seems reasonable. I guess I'm surprised. I kind of assumed there would be one with the electronic, but it kind of makes sense if there's not. But we do paper exhibits, don't we give them an index when we have this many? We don't? Wow.
No, there's a, technically it's supposed to keep track. in their notebooks of what's what,
Yeah,
because I can't give them the list because not everything's admitted all the time.
no, that's what I mean. So we don't, like in a construction defect case, we would, at the end of the case have, 10 million exhibits and here's, that were admitted and here they are.
Yeah, I mean, I just learned it as well, so.
Yeah, that's news to me. Maybe we just do it special in a CD case or a case with a gazillion documents. So we have no objection to the itemized list of exhibits, to be very clear. The physical of the 5-gallon concentrate and the retail bottle of real water, I think those are demonstratives. I don't think they're exhibits. I'm not sure that we can let them see that. I need to talk to my colleagues about that. I mean, it doesn't seem controversial, but I don't know that we can let them see it.
And we could go on the record too, how you do that, that's fine.
And then the rewatching of Mr. Morales, again, I think that typically we would have a read back. Again, I don't object. I wander around the courtroom all the time. The fact that Mr. Pepperman was in the direct line of sight of the camera doesn't, I feel bad for him that we're bringing him up. So, but usually it's a section of testimony rather than hear the whole thing. So that's unusual.
Did you figure out how long?
It's 5220, Your Honor. I was going to give the court another option, which is we can put it on a USB drive and they can play what they want to play.
They have,
Clean,
yeah, they have to clean that up, they can do that.
yeah, 52 minutes.
52 minutes and 20 seconds.
So,
Yeah, I think that's pretty long. We would suggest if that's the option that we're gonna settle on, that it be made at least a court exhibit.
for sure, yeah.
You got a clean USB?
I can't.
I do.
Can they do that if it's not, if it wasn't made an exhibit before they return it over, because they don't get court exhibits, they just get off.
No, we'll,
Yeah, no.
we will give a stipulation, but essentially we call it a court exhibit.
Good question.
And that way it's marked for the record. So on the thumb drive, I think provide everybody's okay and stipulates, put it, or Morales' testimony, put it on the thumb drive, mark that thumb drive as a court exhibit. Although it's a court exhibit, we'd be giving it to the jury to play the portions or as much as they would like. Does everybody agree with that?
Real water agrees.
We agree, Your Honor.
Okay. And then, so we'll leave plaintiffs in charge of getting that, then let defendants see it, make sure it's, what it is. Plaintiffs want to take the lead on the list of exhibits.
We can do that, Your Honor, but I would ask that the defendants, at least initial way, would give the jury some controversy about it.
Oh, sure.
Yeah, I can do that.
Yeah. Okay, so there's two.
I don't
Are
know.
there pictures of the jugs that are admitted or a picture
There are
of the bottle?
pictures. There is a picture of the 5-gallon jug and the retail bottle.
Yeah, I would prefer they get the admitted evidence.
How
Yeah.
they have concentrate?
Well,
The actual
we have
is
we have the 5-gallon concentrate jug.
Oh,
I thought they were talking about the little.
yeah, so 5-gallon concentrate retail, so we could say C.
You could
exhibit.
identify the exhibits for them. Your Honor.
Yeah.
Yeah. And we reached a stipulation on that.
Yeah, we can.
Oh,
We just gotta take a second to find it.
let's go off the record and then, just let us know when, and if you need, if we, I'd even suggest once you have the list of exhibits, we print it, for them, make it easier on them
Yep,
That's fine.
to,
we agree.
okay.
Your Honor, I actually had someone from my office prepare that list last night. I wasn't sure if we needed to provide it, but I have it ready to go. I can email it to Mr. Vera if that's easiest.
Well, email it to defense first, and then they can take a look, and then, go back and forth and go off. So email it to them, they'll review, once everything's agreed to, or if you need my input, just let us know. Any questions before we go back up here?
No, Your Honor.
No, Your Honor.
Thank you, Your Honor.
Oh, no, thank you. Has everybody had an opportunity to review the questions with the answers attached?
Yes, Your Honor.
Question and answers.
Oh, okay.
Anybody have any issues, questions, concerns, objections with giving that to the jury?
No objection, Your Honor.
And to clarify, we do have a thumb drive that both sides reviewed, right?
Mark, are we done with it?
Yes, sir.
Yeah. Yes, Your Honor.
And we have the exhibit list as well. Okay. Anything else?
Nothing on plaintiffs, Your Honor.
Nothing from the bench, Your Honor.
Okay. Thank you.
1169 Christopher Wren versus AffinityLifestyles.com Inc.
Oh, not, no. Okay, before we bring them in, anything we need to discuss?
Your Honor, I don't know if it's appropriate to bring it up now, but if the jury comes back and awards punitive damages, I think we will just need a few minutes to finalize the verdict form and one instruction that's already been ruled upon. And we would likely call one witness via Zoom and just to have that set up. But that's the only thing from our end.
Your Honor, we haven't been given notice of a witness. I have a guess as to who it might be, and we have an objection if it's that person.
Tell them it'll be a couple minutes. Okay, let's talk about that stuff then right now. So I did rule on the punitive damages already, giving plaintiffs first proposed, not defendants, and not plaintiffs second proposed, right?
Yes, Your Honor.
And then the verdict form, I don't know the punitive damages verdict, which may or may not be moved, but both sides agreed. If they have checked, yes, the verdict form is we, the jury, return the following verdict, one, punitive damages awarded, gets real water falling now. Blank number one, is that right?
Yes, Your Honor.
Is that correct?
Yes, Your Honor.
Okay, so that's that on the record, so that's good. So plaintiff's witness, potentially, would that be?
Mr. Rich, Your Honor.
Rich, RIC.
And Your Honor, rather than spend a half an hour debating this at this point, I think we probably ought to take the verdict and see if we need to debate.
So who was the name again, just?
It's Mark Rich, R-I-C-H. He's an accountant to file an expert report. His deposition's been taken.
Okay. All right. Okay, so we'll bring them in and then, set up whatever if we need to. Okay. Welcome back, ladies and gentlemen. Thank you for your service and patience as always. Do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Has the jury selected a foreperson?
It would be me.
Okay. So Ms. Stoddard, have at least 6 of the 8 jurors agreed upon a verdict?
Yes, sir.
Please provide the form to Marshal Walker. Thank you. The clerk will now read the verdict out loud.
District Court, Clark County, Nevada, case A21831169, Department 15, Christopher Noah Wren, a minor child by and through his parents, Christopher Brian Wren and Emily Wren, husband and wife. Christopher Brian Wren on his own behalf, Emily Wren on her own behalf. Hera Carrier, a minor child, by and through her parents, Ryan Carrier and Erica Carrier, husband and wife. Lyric Williams, a minor child, and London Williams, a minor child, by and through their mother, Shantae Williams. Severin Morales, a minor child, by and through his father, Jorge Morales. Joseph Tigano, an individual, versus AffinityLifestyles.com Inc., doing business as Rural Water, a Nevada corporation, Rural Water Inc., a Delaware corporation. We, the jury, return the following verdict. Minor children with acute liver failure, filling the amount of damages for past physical and mental pain, suffering, anguish, disability, permanent injury, and loss of enjoyment of life. Christopher Noah Wren, $4 million. Hera Carrier, $5 million. Lyric Williams, $6 million. London Williams, $4 million. Severin Morales, $6 million. Filling the amount of damages for future physical and mental pain, suffering, anguish, disability, and loss of enjoyment of life. Christopher Noah Wren, $5,250,000. Hera Carrier, $5 million. Lyric Williams, $5 million. London Williams, $5 million. Severin Morales, $6 million. Do the following children need future neuropsychological monitoring and treatment? Christopher Noah Wren, yes. Hera Carrier, yes. Lyric Williams, yes. London Williams, yes. Severin Morales, yes. Adult plaintiffs with acute liver injuries, fill in the amount of damages for past physical and mental pain, suffering, anguish, disability, permanent injury, and loss of enjoyment of life related to the adult plaintiff's own injuries. Christopher Brian Wren, $2 million. Emily Wren, $500,000. Joseph Tigano, $3 million. Fill in the amount of damages for future physical and mental pain, suffering, anguish, disability, and loss of enjoyment of life. Christopher Brian Wren, $2 million. Emily Wren, $500,000. Joseph Tigano, $4 million. Parent plaintiffs, fill in the amount of damages for past mental anguish related to his or her child's injury. Christopher Brian Wren, $1 million. Emily Wren, $2 million. Ryan Carrier, $1 million. Erica Carrier, $2 million. Shantae Williams, $5 million. Jorge Morales, $3,500,000. Fill in the amount of damages for future mental anguish related to his or her child's injury. Christopher Brian Wren, $1 million. Emily Wren, $2 million. Ryan Carrier, $1 million. Erica Carrier, $2 million. Shantae Williams, $3 million. Jorge Morales, $3 million. Punitive damages. Is Rural Water liable for punitive damages? Yes. Dated this 14th day of June, 2024, Mary Stoddard, jury foreperson. Ladies and gentlemen of the jury, are these your verdicts, right?
Yes.
Yes.
Does either party desire to have the jury individually polled?
No, Your Honor.
There you go.
Okay, the clerk will now record the verdict in the minutes of the court. Ladies and gentlemen, we'll go ahead and take a break before we go into the punitive damages phase. So, you'll hear this again. During this recess, you're admonished not to talk or converse amongst yourselves or with anyone else on any subject connected with this trial. Do not read, watch, or listen to any report of or commentary on the trial or any person connected with this trial by any medium of information, including without limitation to social media, text, newspapers, television, internet, radio. Do not visit the scene of any events mentioned during the trial. Do not undertake any investigation. Do not do any posted communications on any social networking sites. Do not do any independent research, including internet searches. Do not form or express any opinion on any subject connected with the trial until the punitive damages phase of the case is finally submitted to you. So you go to a break back in the jury room, and when we're ready to begin that, we'll bring you back.
Please rise for the jury.
Okay, have a seat. So issues to clear up or clarify?
I think Mr. Odou should start with his objection.
Okay.
Mr. Zamora, use the screen to be much quicker that way, and I can show you the problem.
Sure.
Did you get the, yeah, I'll tell you what page.
Yeah, no worries.
Must have bumped my computer because I was on the right page and now I'm not.
Of course.
Yeah, I bumped my computer. Mr. Zamora, could you go to page 139 of the PDF I sent you, please? Your Honor, Real Water objects to the calling of Mark Rich under 16.1. In particular, Mr. Rich was designated as an expert in this case. He was designated as an expert. He provided a report that was substantially similar to the reports he's provided in the other cases. He hasn't testified in any of the other cases to date. Doesn't mean he won't in the future. In particular,
And I apologize, you said he has not yet.
he has not, he's not been called, Your Honor. So this rule, this issue is right for this court, and we don't have the guidance of any of the other judges. As you'll see from page 1 of Mr. Rich's report, the second paragraph, he has been, as part of this engagement, I've been asked to analyze various financial and other data related to potential punitive damages against Hannah, defendant Hannah Instruments, Milwaukee Instruments, all the defendants except for Real Water, Your Honor.
Oh.
The word Real Water does not appear in his opinions. So that's the first objection, Your Honor. It's Mr. Rich in his opinions. I'm not saying about his designation, I'm only talking about his report. His report does not mention Real Water. I did not attend his deposition because at first blush it would appear that he does not have opinions as to Real Water. His deposition was taken. I'm sure some attorney from my office attended on behalf of Real Water, so I'm not saying that we didn't have the opportunity to cross-examine him. I'm just saying that we have a straight-up 16.1 violation in that his report does not include opinions about Real Water. If we go to the page that is it's page 140 of the PDF, Mr. Zamora. And obviously, in the case background, again, he talks about, among the claims asserted in this case, this is the second paragraph, plaintiffs allege that real water was defective and so forth. And talks about the trier of fact will render punitive damages. I assume plaintiffs will argue as to real water. Then if we scroll down, we will see that his next section of his report is punitive damages against parties that are not before the court and in Milwaukee. We go to the page that is PDF 141. He has opinions as to UNFI. And halfway down the page, opinions as to Costco. And then he explains the purpose of exemplary damages at the bottom of that page. In his explanation of punitive damages, in the second paragraph under exemplary damages, he says, following, I'll just quote, in order for a punitive damage award to have any meaningful deterrent effect on a multi-billion-dollar company, the award would have to be significant. However, even an award of $2 billion will be less than 1% of Coca-Cola's estimated $553 billion market cap, less than 1% of Pepsi's estimated $247 billion market cap, and less than 1% of Nestle's estimated $309 billion market cap. And then he goes on to other industries. I'm not sure if those are water-related industries. So, Your Honor, and then if we skip to his conclusions, which is on page.
Hold on.
Yeah.
Can we keep it down over there, please? Thank you.
Right.
No worries. If we skip down to his conclusions, it's on page 142 of the PDF, Mr. Zamora, and then we look at the second to last paragraph. You can just make that so we can read it. Again, he talks about, in the concluding sentence, and I'll let the court read the whole paragraph, but my point is going to be as to other large companies with operations in the bottled water industry, such as Coca-Cola, Pepsi, Nestle, including ORP meters, manufacturing companies such as Thermo Fisher and Granger. So here's our point, Your Honor. Let's say hypothetically that this was a car accident case, and plaintiff was attempting to draw an award of punitive damages for the reprehensible conduct of the driver driving a company car for, I don't know, let's pick a medium-sized Las Vegas company. Let's say Capriotti's. Comparing Capriotti's to General Foods or, I don't know, the big mega corporation like Beatrice is the one that I recall from my childhood, would not be a fair comparison. Your Honor, the law is very clear in the danger of confusion for a jury in punitive damages. They are to look at the reprehensible nature of the conduct. What the plaintiffs are trying to do is they're trying to draw a distinction and say, look, real water is part of a multi-billion-dollar industry. That is not one of the factors. And the reason why we argue that this factor, let me say that differently. While they will argue that that's one of the factors, they're abusing that and taking the exception to the rule and destroying the rule. And what I mean by that is the issue is the conduct of real water, not the conduct of real water because it is part of a multi-billion-dollar industry. That is a happenstance. Whether or not the car accident is driven by a driver who drives for Coca-Cola or drives for Pepsi or drives for water matters. It matters so that the jury will return a verdict in the ballpark of what would subject the defendant, in this case, real water, to adequate punishment. The plaintiffs will attempt to interject issues of insurance, that's collateral source. Doesn't matter that real water is insured by an insurance company who has a lot of assets. That issue is not and never will be before this court in this trial. That issue may be before a future court in another trial. And they have their various arguments as to why it could be before a future court in another trial. But be that as it may, the jury needs some basis to award damages against real water. Mr. Rich had every opportunity in 3 cases now to write a report as to an appropriate punishment of real water, and I know the court has ruled and disagreed with us on this. In 2 cases, and I know this court has touched on it, but I think it bears repeating. that the financial annihilation rule, it shouldn't just be taken in a vacuum. Yes, there's a financial annihilation rule. Yes, the plaintiffs have argued that Real Water annihilated itself by declaring bankruptcy. I strongly disagree with that. The right to bankruptcy is a constitutional right. If we look at the framers, that was a very important right, and the reason why we have in America and not Great Britain form of justice. Be that as it may, the right to declare bankruptcy is an important right, and we're going to trample that right by saying we're going to punish Real Water because they are financially bankrupt, and therefore the financial annihilation rule does not apply to them. And instead, we're going to allow this jury potentially to hear evidence of what it would take to send a message to the bottled water industry. We think that is wrong. We think that would be an error, and we think that that would be a verdict based on passion, prejudice, and not on evidence. And calling Mr. Rich to offer this type of inflammatory evidence as to the value of the bottled water industry would absolutely be an error. I need one quick moment, Your Honor. I had a case site that my colleague sent to me, and I went to my computer and also lost that. See if I can find it really quick. So, I believe, it's coming up, I think it's a white case. Your Honor, to save time, I can, if I find the site, I can provide it in response to the plaintiffs. But I think it's the white case that I don't have. I have hit the wrong button,
That's,
so I apologize.
no, when you find it.
Okay. Good afternoon, Your Honor. I want to reframe this argument, Your Honor. Mr. Odou would like this court to accept that Real Water can file bankruptcy and use it as a sword as well as a shield. That's how this court should consider the context and the content of Real Water's argument. Because they use that first as a sword and shield, which I'll explain, but they also create the straw man argument. Your Honor, when Real Water filed bankruptcy, it did so to avoid the consequences potentially of this litigation and many others. That's, of course, the shield. And in terms of how they've used it in the last three cases, where a small company or a family company, knowing full well there's not a nickel our clients can get out of them because of the bankruptcy. Your Honor, right now, Mr. Odou has attempted to use this bankruptcy as a way of getting around the consequences of what this jury has decided. Now, in terms of Mr. Rich, looking at his report, and I do appreciate what Mr. Odou said about Real Water's finances, but Your Honor, our expert couldn't address their finances because of their bankruptcy. That's the sword. They put us in a position where their finances are of no consequence. It's of no use. We can't use their finances in any way to persuade the jury to give us a single penny. And so we're left looking at NRS 42.005 as trying to persuade this jury to award punitive damages based on the example it should set and to deter others, which is consistent with the Ace trucking case. So NRS 42.005 says as an example, the Ace trucking case says to deter others, and Your Honor, what others are there? Who else could it be? We can't deter real water any further. The only thing we can do now is deter other water bottling companies to prevent them from committing the same misconduct. Now, if you look at the actual instruction that the court has approved, this instruction doesn't limit it to a particular company or a particular type of company. It just says others from engaging in conduct such that warranted punitive damages in this case. That's considered a conduct. The conduct deals with food and beverage based upon the FDA regulations. So what we're trying to do, and the only way you can make sense of the Ace trucking case, NRS 42.005, is that these punitives are going to be used to prevent similarly, I would say similar, people in the industry, in this industry, from committing those same things, those same violations to real water.
Yeah, thank you. Tell me about, because I'm extremely likely is how I put the level, and that might be a little low, but, you know, the instructions I've already ruled on, and so, you know, deterrence and others. But tell me about Mr. Rich in terms of, because you just said, well, he couldn't address the finances, and therefore that's why, you know, we don't have real water, and I'm adding to what you said, but that's why we don't have in the report real water as a separate entity that he's addressing. Well, if that's the case, why is he relevant to testify now?
Great question, Your Honor, and let me help you through that. First page of his report.
And I don't know, do
You
you
have
have it printed?
I got it printed, you can take mine, Your Honor, I kind of remember it.
Okay.
Can I approach?
Yeah,
I got some highlights there, Your Honor, that could help. I just highlighted where it says Coca-Cola, Nestle, Your Honor. The point being is, he was talking about the industry that real water is involved in. And that's what and we've talked about that earlier. From Dr. Hutt to Dr. Olson, the industry and what's appropriate has been discussed throughout this trial. And so what he did, and Your Honor, I want you to remember this in particular. Anthony Randolph testified that one of the reasons they got involved in this, this company was involved in it, is to take advantage of a $21.7 billion industry. That was as of 2011. That was the water bottle industry.
so say that again, because that
Sure.
was right. I was
Sure.
trying something different.
No worries. So Anthony Randolph, the former vice president of distribution and sales for Real Water, testified based upon their business plan that there was a $21.7 billion bottled water industry as of 2011. That's the industry that we're addressing here. That's the industry that Mark Rich addressed in his report. And if you see page 1, page 2, you'll see the highlighted portions where he speaks about the industry. Now, Mr. Odou alluded to this, but I want to confirm it for the court. June 6, 2023, Mr. Rich was deposed. April 4, 2024, he was again deposed. Real Water didn't ask any questions. They chose not to ferret out the industry issues raised in his report.
But was somebody there on behalf of Real Water?
I'll accept Mr. Odou's comments that someone there was there.
Oh.
The other thing I want to point out, Your Honor, and hopefully Mr. Odou will remember this, Judge Williams actually approved the use of our expert the night before we got a determination on punitives. We didn't have to use them because it was in relationship to Hannah. But ultimately the jury did not grant us punitives against Hannah, so we didn't have to use them. Again, because Real Water is in bankruptcy, there was no reason at that point. So we were going for deterrent, we were going again for the industry, and that's how we argued to the jury on it. So, it's my recollection that Judge Williams did allow us to do it, or at least indicated his intention to allow us to bring Mr. Rich on. The other thing I wanted to argue, Your Honor, and I know Mr. Odou didn't raise this, but I'm gonna put it on record. He's not raised any hallmark issues in terms of Mr. Rich. And so I wanna make sure the record is clear. He's completely qualified to give these opinions. He is aware of the industry, the bottled water industry in particular, Your Honor. Our questions to Mr. Randolph, our questions in terms of Mr. Rich will be related to the industry. We will not raise issues or ask questions regarding Real Water's financial status in any way. We certainly would not hazard taking a chance of the bankruptcy being thrown out there or anything like that, or insurance. But given that they had the opportunity to question him at 2 separate times, given that the industry information, including Coca-Cola and Nestle, was brought up, we discussed the industry, in fact, during voir dire, just generally. And we had Dr. Hutt and Dr. Olson talk about the industry, Your Honor. And this is the industry that we're trying to deter others from committing these same forms of egregious conduct or reprehensible conduct.
I think you mentioned, and I was busy writing something else, but I think you confirmed, but correct me if I'm wrong, I think you said plaintiffs will not be mentioning or raising anything vis-a-vis insurance, right?
No insurance, no bankruptcy. We won't mention or raise issues regarding the water's financial status in any way, Your Honor.
Thank you.
Thank you.
Judge, I had one minor point that I wanted to add to Mr. Parker.
Okay.
Assuming that the jury does award punitive damages, and whatever the number is, 100 million, 200 million, 300 million, this goes up on appeal. And if there's no context for the punitive award, that's Mr. Odou's creation. So, I mean, they could come in here and give $1 trillion of punitive damages, and he, or more accurately, the person who's ultimately responsible, won't be able to challenge that. We don't think that's appropriate. We think there should be some context, at least the size of the bottled water industry. You know, otherwise the jury's just, I don't want to say picking a number out of the air, but that's what he's really asking them to do. And I don't think that's appropriate, and I don't think that, I don't think there's a situation where we waive the objection, but.
So you're saying there should be some linked evidence?
There should be some, if we're deterring others, it's others in the bottled water industry. So at a minimum, we should be able to get into the total size of the bottled water industry. You know, whether we go down the top 10 bottled water people, I don't know if we go that far, but at least they should have some kind of idea that I think it's an $85 million or $1 billion industry. But the jury should have some kind of idea, so they just don't, just take some number out of thin air. That's why I think it's important to give them some sort of context.
Thank you. So I'll have this, and this is kind of coming out of the blue, so I apologize, but some of this is out of the blue to me too. In terms of, so part of defendant's argument is that, there's this high danger of unfair prejudice where if we're talking about billions, there could be, punitive damages or that's, greatly in excess of anything that could be warranted. Is there a mechanism? So I'll ask plaintiffs first, and then Mr. Odou, you can address in rebuttal. Any mechanism by which the court could potentially address that post-verdict?
Yes, Your Honor, there's the constitutional limits. So in Nevada, we have 2 cases. The highest that the Supreme Court has approved is 12.5 and 12.6 to 1. And then there's a 12 to 1. Both of those are bad faith insurance cases. There's an argument it should be higher because this is the highest form of punitive damages, given that it involves public welfare and safety. But after, let's say the jury awarded $5 billion. We're not going to ask for that. Let's just say that for hypothetical. The court would have to take the compensatory total compensatory award is $93 million. It would have to find a multiplier within constitutional limits. Whether that's a single-digit multiplier, whether it's 12. the court would have to cut back down to
And
that
that'd be a post-verdict.
post-verdict thing. And, you know, we talked about this in front of Judge Williams, because in one of my cases, I think the award was $505 million, and he cut it down to, I can't remember what he cut it down to, $330 million. You know, so I lost $170 million in a minute. And I didn't complain, because that's, I felt bad about it. I felt bad, but I didn't complain, because, you know, you do have to apply the constitutional limit, and that's what happens with the court afterwards.
Thank you very much. Mr. Odou.
Thank you, Your Honor. I found the site, but I'd also like to, of course, respond to Mr. Parker and Mr. Kemp. So the site was, we were a couple of days ago arguing Philip Morris, and we looked a little bit beyond Philip Morris. We looked at White versus Ford Motor Company, 500 F 3rd 963, page 962. It's a Ninth Circuit decision.
So what was the page number?
963 and 972.
No, okay, 9-7.
And it's a Ninth Circuit opinion from 2007 citing the Williams Supreme Court case. The gist of it was the jury can consider evidence of actual harm to non-parties as part of its reprehensibility determination, but may not use punitive damages to punish a defendant directly.
Say that again. Sorry. Let me pull it up.
Yeah, sure.
Yeah, that'll make it easier for me.
And I'll warn the court, it's not directly on point to what we're talking about.
That's
So basically what the court was talking about is what we've been talking about for the last week, the reprehensibility determination and using non-parties for the reprehensibility determination. But the court may not use punitive damages to punish the defendant, or may not use the evidence from non-parties to punish the defendant directly. And the court talks about a significant risk that jurors will misapprehend the distinction, and that the court should, upon request, protect against the risk by avoiding procedures that unnecessarily deprives juries of the proper legal guidance.
So does this go to the instruction that you could have asked for but did not, or?
No, this still goes to the issue, and I was going to go make my argument to what Mr. Kemp just said, which is Mr. Kemp rightly said that the defendants object to the punitive damages awards in the prior two cases and will object to the punitive damages award in this case based on the fact that the jury does not have some evidence to make the award. And the reason why the jury does not have some evidence in the prior cases in our argument, I'll make the same argument here, is we had Anthony Randolph on the stand. Anthony Randolph could have been called to testify in the punitive damages stage as to real water sales. There are numerous records that Mr. Randolph has. He was a commissioned salesman. He knows the revenues of real water. He is in the state of Nevada. He could have been called and cross-examined as to the revenues of Nevada. I'm sorry, revenues of real water in Nevada. We also had, and we'll make an offer of proof now, that Brent Jones' testimony, which could be played for this jury, it's queued up and ready to go, as to the fact that real water at its height sold about $9 million worth of water in its best years, right around the time before COVID. And that $9 million a year was revenues, not profits. That's the best the company ever did. And I'll be very candid with the court. The other two judges said that that evidence is not relevant because it's not current. Our counter argument to that is you've got to have something. You've got to have some evidence. Yes, the company's revenues now today are zero. That is an undisputed fact. But I agree with Mr. Kemp that there's gotta be some evidence, and I would point out that there has been no evidence offered, and there will be no evidence offered by Mr. Rich, and it appears that there won't be any evidence offered in this case. And we want to preserve that issue on appeal because, again, we're not talking about the financial annihilation, we're talking about giving the jury something to anchor their verdict to, giving them some tie to reality. Now, Mr. Parker said that they don't have Real Water's financials because it's broke and out of business. Well, the reality is they didn't want Real Water's financials. They are advantaged by Real Water's bankruptcy because Real Water only made about $9 million in revenues, and if you want to, get down to the profits, obviously it's a lot less than $9 million a year. And telling this jury, punish this defendant for $9 million a year in profits even, that's not what this case has ever been about. It's always been about $1 billion or more from the get-go and jury voir dire up until the present. Our argument is Real Water shouldn't be penalized by its bankruptcy. At most, the court should do whatever it can to even the playing field between the bankrupt Real Water and the plaintiff's rightful entitlement to punitive damages, which has been found by this jury. The jury has made the finding. It's just like this court has ruled. That's the rule. There's going to be punitive damages, and we respect that. But we say that there's got to be some evidence to support that finding, whatever that may be. And then finally, again, Mr. Kemp talked about the constitutional issues. Obviously, this is a product defect case, looking at a statute which ties compensatory damages to punitive damages. Does not apply here. There's not a cap. Mr. Kemp argues about 12 times to 1. So that's an obscene amount of money, even if it's $1 billion. $1 billion, and I'll say that argument for the jury, is an obscene amount of money. But again, it's a problem. I said this to Judge Williams, I said this to Judge Kishner, I'll say it to this court. It's a problem. How do we provide evidence that the jury can render a just and fair punitive damages verdict? We submit that the only way to do that is on evidence of Real Water's financial condition before the bankruptcy and giving benefit of the doubt to the plaintiffs that that was their best years ever. I understand the plaintiffs won't disagree with that. They want instead, though, to argue punitive damages based on Coca-Cola and Pepsi, and that's too much. And it's a problem. The courts have wrestled with it. Your Honor's going to have to wrestle with it and make a decision, but we do want there to be some evidence. We just don't believe that Coca-Cola and Dasani or whoever is relevant. I'm happy to answer any questions the court has.
I don't have any more questions, thank you.
Sure, briefly, I think we're
Okay, don't get the last words.
you're conflating two issues. This due process, the White case, you brought up the White case. That case was a case on the jury instruction. And it says, quote, due process error arising from district court's failure to give a harm to non-parties instruction.
Yeah, that's why I asked.
Yeah, and they didn't ask for that instruction, so what does that have to do with anything? So the real issue is, there is no punishment here because this company punished itself, it filed bankruptcy. So the only issue is what is proper evidence to give the jury some sort of framework for deterrence. That's really the only issue. And I don't want to repeat anything I've said, but I think Mr. Odou agrees with me. He said, quote, you have to have something to anchor the verdict on. I mean, what else is there other than the size of the bottled water industry? If the bottled water industry was, in the entire United States, was a total of $10 million, I think you'd be jumping up and down saying we should be able to give that figure. It is what it is, Your Honor. And so I think that's really the appropriate figure to give.
Anything further, Mr. Odou?
No, Your Honor. Thank you very much.
Thank you all. So I'm ready to rule. I'm going to deny or overrule, however you want to put it, Real Water's objection. For a few reasons, and it's, an issue rather than an overarching issue, I guess is I would say. So reasons behind this. So I denied, and these are all additional or alternative type of reasons, taking into account totality of the circumstances and all the evidence, all the arguments. So I denied plaintiff's proposed jury instruction number 2. And so they will not have an instruction that says, essentially disregard the size of the company. So that's fair argument. So that's, potential offset to the industry argument. The industry argument, I think, is a proper type of argument, given, my prior review of those other cases that I don't know that we discussed a whole lot, but I certainly did review them, those Supreme Court cases, when they were raised, and we had some discussions on those. We have Nevada here, East Trucking case, et cetera. Whether you call it context through evidence or anchor a verdict to evidence, there is a real good argument, and I agree with it, that there should be evidence to anchor and give context to damages arguments that I'm sure counsel will be making on issues with notice vis-a-vis Rule 16 and Mr. Rich's report. And I haven't even seen the depot transcripts, but certainly he sets forth in his report, enough to put real water on notice of, hey, here's, what did we talk about it? Punitive damage, he's gonna be testifying potentially about punitive damages. Looking at the top of page 2 here, quoting also serve as an important cautionary example to the multi-billion-dollar bottled water industry as a whole, in order to get the attention of these companies, so there's certainly notice there that that's what he's, proposed, retained, to potentially testify about. Anthony Randolph, I don't remember him testifying to that, but I'll assume that was a good faith representation of testimony, of his testimony regarding the $21 billion industry. No hallmark issues were raised regarding Mr. Rich's proposed testimonies, qualifications, etc. The court instructs / orders plaintiffs not going to be talking about bankruptcy or insurance, and I'll hold you to that. Mr. Rich was deposed twice. If Real Water had questions to follow up, we could have done that at the time. This isn't punishing Real Water for bankruptcy. It's trying to think of a better way to put it. But it's not punishing Real Water for filing bankruptcy. It just, plaintiffs have to deal with the evidence that we have, and if the award is, unconstitutional in some aspect and or deserves some type of reduction otherwise, there are post-verdict, there's post-verdict relief which can be sought fire or water, that I'd be more than willing to consider. Let's see. So deter, defendant, and others being the industry, the players in the industry. So for all those reasons, denied/overruled. Can we take a quick break before we bring them?
Yes, Your Honor, before we do that, could I please confirm that Mr. Rich will appear via Zoom? We sent him the regular blue jean, or?
I didn't want to do that, so I made up a new one for just today. I sent it to Shane to give to you guys.
Okay, perfect, thank you, we'll send that. And then I do believe that we will need the printed copies of the finalized jury instruction and verdict form. I don't know that we ever received that back from Ms. Rivera.
You need the printed copies?
Whatever the court needs, I just don't know that we have the final.
Oh, I mean, you mean for the punitive?
For the punitive.
Okay, looks like, I thought we already did them. Yeah, so they're here. I mean, do y'all wanna see them right now?
I just wanna make sure they're the same ones we have, Your Honor.
Yeah, you
Plan
can
on putting them on the screen.
all of you guys come on up, make sure. Oh, yeah, okay, there you go. We have copies.
Oh, excellent.
Oh, perfect, thank you. May I approach?
Yeah.
Thank you. Your Honor, can I get that answer from Rich? I'm gonna read it.
Oh, yeah, yes.
Thank you so much.
I was thinking you were gonna ask me to hole punch something.
I am, you know, putting myself in the box on that one. Thank you, Your Honor.
Yeah, you're welcome. Anything else before we take a quick break?
No.
Nothing else, Your Honor. Thank you so much.
Ready to proceed?
We are, Your Honor.
Thank you.
You're welcome.
Okay. It's rolled.
Good afternoon, ladies and gentlemen.
Good afternoon.
Good afternoon, Mr. Rich. How are you?
Good.
Can you hear me very well?
We need this.
Maybe a little more volume would be good.
Well, we're doing that.
Yes. Thank you.
Please raise your right hand to be sworn in. You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state and spell your first and last name for the record.
Mark Rich, MRK RICH.
Can you hear me, Mr. Rich?
Yes.
You can? Okay, perfect. Thank you. Mr. Rich, could you please inform the jury? And by the way, can you see the jury?
Not quite. No, I cannot.
You might be able to see me.
Oh, okay. Well, they're right in front of you. They can see you.
Okay.
Okay? So, Mr. Rich, can you tell me what your profession is?
I'm a certified public accountant. I'm also certified in financial forensics.
And what's the difference between those two?
Well, a certified public accountant deals with tax and audit and financial matters and such, but a certified or being certified in financial forensics, you deal in more complex accounting and business matters that tend to be high dollar amounts.
Yes, sir. And how many years of experience do you have?
I've been a CPA for over 40 years and a certified in financial forensics for over 10 years.
And who certifies you in the financial forensics environment?
The American Institute of Certified Public Accountants.
And what are the requirements to be able to qualify for such a designation?
Well, there's a requirement for experience in that field, and there's also an exam that you take similar to the CPA exam where you have qualified by examination.
Yes, sir. It's my understanding, Mr. Rich, that you've been engaged here by the plaintiffs to take a look at this case and give an opinion or determination as to the bottled water industry. Is that a correct statement?
That's correct.
And have you done so?
Yes, I have.
It's my understanding that you've looked at Coca-Cola, Pepsi, Nestle as just an example of the bottled water industry.
That is correct.
Are those some of the bigger players in the bottled water industry?
Yes, those are probably the biggest. Nestle being globally one of the largest.
And based upon your review of the bottled water industry, have you come up with a determination or some form of opinions in terms of the size of the bottled water industry?
Yes. Globally, the bottled water industry is probably 300 billion. That segment. In the US, which is one of the largest components of the global market, in 2022, it was 85 billion. It's estimated in 24 to be about 95 billion. And there's an anticipated growth rate in the bottled water industry to be at least 6% per year. And by the year 2030, it's anticipated that the bottled water industry in the US would be somewhere around 135 billion.
Yes, sir. So let's just focus on the US at this point. It's my understanding, based on what you just said, that the US bottled water industry is about approximately $85 billion.
That would be in 22, and in 24, it's anticipated to be about 95 billion.
Yes, yes, sir. Are you aware that Anthony Randolph, former Vice President of Real Water Sales and Distribution Vice President, testified regarding what the value of the bottled water industry was in 2011?
Yes.
Let me play that for you, if you could. I want to get some, your opinion of this. If you could, Shane, could you play?
While he's queuing that up, Your Honor, same objections before.
Thank you, Senator
Yes, could you play slide 27 for me, please?
There's no video on this slide, Mr. Parker, would you like?
Oh,
to-
just show the, I'm sorry. Yeah, put the slide up, and hopefully he can see it. And if we need it for purposes of the court hearing it, we could. So,
Yeah. Can you see that?
Can you see it?
Yes.
Do you recall Mr. Randolph actually testifying to that during this trial?
Yes.
And given the numbers that you've given this jury, is that consistent with your evaluation of the growth of the market since 2011?
Yes.
And do you give that opinion to a reasonable degree of forensic accounting, probability and/or certainty?
Yes.
You also authored a report in this case, is that correct?
That is correct.
And based upon your examination of this industry, do you believe that a percentage of the bottled water industry, and to determining an appropriate punitive damage amount, of course, not taking it away from the jury, would be something necessary to create an impact?
Objections, speculation, and seeing the objections before.
So it's sustained in terms of rephrase your question? It's leading.
No, I can rephrase that. Thank you, Your Honor. Mr. Rich, have you ever done an analysis based on the appropriate amount of punitive damages?
Yes,
And did you do a similar analysis in this case?
yes.
Based upon your analysis in this case, based upon the bottled water industry, what type of punitive damage award would be necessary to have a positive effect on the industry?
Objection, speculation, 16.1, A2, and also the same objection as before.
Overruled on all these grounds.
You can answer, Mr. Rich.
Yes, I believe in my report that I indicated that a $2 billion punitive damage award would be nominal to this industry. It would be less than 1% of the market value of companies such as Coca-Cola, Pepsi, which is Aquafina, Coca-Cola's Dasani, and Nestle.
Thank you very much, Mr. Rich. I'll pass the witness.
No, I won't be very long. Thank you, Mr. Parker.
You're welcome.
Mr. Rich, I'm going to stand near a microphone. Can you hear me okay?
Yes, I can, thank you.
Ladies and jury, good afternoon.
Good afternoon.
Mr. Rich, good afternoon. I'll be very brief. I just want to make sure you can hear me. If at any time it glitches or you can't hear me, just let us know. Got basically 3 categories of questions for you. Coca-Cola, do you have an opinion as to how many employees Coca-Cola has in the state of Nevada?
No, I do not.
Do you have an opinion how many employees Coca-Cola has in the United States of America?
No, I do not.
Do you have an opinion how many employees Coca-Cola has worldwide?
No, I do not.
Would you say it's a lot?
I would say it would be thousands in each case.
I'm sorry, it did glitch. There we go, I predicted the future. I didn't hear your answer, sir. Maybe the jury did. What was your answer? I apologize.
I said it would be thousands.
Thank you, sir. If I ask you the same question for Pepsi, would it be about the same? You don't know, but thousands of employees?
Yes,
And the same for Nestle?
yes.
Thank you, Mr. Rich. I don't have any further questions.
Nothing further, Your Honor. Thank you so much.
Mr. Rich, thank you so much.
Any questions from the jury? Okay, thank you, Mr. Rich.
Thank you.
Objection.
Oh. I'm sorry.
He's gone.
Oh, we need him back on?
Yeah.
Can, we're doing it right now. Thank you, Mr. Yeah.
Council can come up with. Mr. Rich, can you hear me? Oh, he's on mute. Bear with us a second here. Might be, are you muted on your end, maybe?
Is that better?
Yeah, okay. You understand you're still under oath?
Yes.
Okay, so we have a question from one of our jurors. What percentage of the amounts you stated pertains to alkaline water?
Alkaline water is a part of the bottled water industry, and I'm not quite sure. It would be a smaller percentage though, because it is a unique portion of the bottled water industry, but I'm not quite sure what percentage that would be.
Thank you. Any follow-up questions from plaintiffs?
Yes, Sean. Mr. Rich, can you hear me?
Yes,
The alkaline water product, is that simply a part of the industry?
yes, the analysis that I've seen, and a lot of the information we get, is research material that's provided by Dun & Bradstreet. And they tend to group those bottled water industry as one, considering it to be an industry bottled water. And there are various variations of that. You know, spring water, you see those products on the shelf. And so they really don't break that out in, you know, the detailed analysis with the gross volume and things of that nature.
Yes, sir. So be it spring water, vitamin water, alkaline water, they all make up this bottled water industry?
Yes.
So when you gave the opinion earlier, what impact or what amount would be necessary to have a positive impact, that was for the entire bottled water industry, regardless of the type.
That is correct. And our analysis indicates that most of these companies are larger companies that branch into these other areas.
So be it a larger, middle size, big size, regardless of the size, they all make up a part of this overall bottled water industry?
That is correct.
And they're all competing for this $85 billion worth of market share?
Yes,
And your opinion was one developed to address everyone participating in that market?
that is correct.
No further questions. Thank you, John.
Mr. Rich, Joel Odou for Rural Water, can you hear me?
Yes.
Are you aware of any other alkaline bottled water manufacturer that uses titanium tubes as part of their process in manufacturing?
I'm sorry, repeat that question.
Are you aware of any of the other manufacturers of alkaline water, whether it be Pepsi, Nestle, Coca-Cola, whoever, using titanium tubes to electrify their water as part of their manufacturing process?
I'm not aware of that, no.
Thank you.
Nothing further, Your Honor.
Any questions from jurors? Okay. Thank you. Thank you, Mr. Rich. Okay. Who else can come approach?
With that, plaintiff rests. Of all evidence.
Thank you. Anything from the defense?
No, Your Honor, yes.
Okay. So ladies and gentlemen, I will now instruct you one single instruction on this phase. So jury instructions, punitive damages. Instruction number 1. And again, you'll have this when you go back to deliberate. Instruction number 1, there are no fixed standards for determining the amount of a punitive damage award. The amount is left to your sound discretion to be exercised without passion or prejudice and in accordance with the following governing principles. The amount of the punitive damage award is not to compensate the plaintiffs for harm suffered, but what is reasonably necessary to punish and deter the defendant and others from engaging in conduct such as that warranting punitive damages in this case. In arriving at any award of punitive damages, you are to consider the following. 1, the reprehensibility of the conduct of the subject defendant, and 2, the amount of punitive damages that will serve the purposes of punishment and deterrence. With that, are plaintiffs ready to argue?
We are, Your Honor.
Okay.
Good afternoon again.
Good afternoon.
Try to be brief. Let me give you a playbook. We get to argue again, myself and I believe Mr. Pepperman will also argue. The defendants, Real Water, will be able to come and argue as well, and then we get the final rebuttal. So that's how this will proceed. Okay? If you could, Shane, let's start with slide number 1, please. Now, I'm not sure if Mr. Odou will say this, but I suspect. I believe he will say that Real Water is a family-owned business as opposed to simply asking you to consider what Real Water has done, how Real Water has acted, and try to perhaps invoke some form of sympathy. That's not why we're here. We're here in phase 2 because you have decided that their conduct was so reprehensible, so egregious, that some form of message, some form of deterrent had to be made today. And that's what we're going to ask you to do. Because when you consider that Mr. Odou may get up and say this was a family-owned business, I want you to consider first these families, and how these families were affected by Real Water. Next slide, please. And I want you to consider this. Henry Ford founded the Ford Company in 1901. You all know the Ford Motor Company. And at this point, that company has a $176.24 billion annual revenue, 177,000 employees. Sam Walton founded Walmart in Rogers, Arkansas in 1962. Has 10,500 stores, 19 countries, employs 2.1 million associates around the world, 1.6 in the United States alone. Remains the #1 richest company for the 10th consecutive year. $573 billion. I raise that point because family business, public company, it doesn't matter. It is a company that has the force and effect to affect not only these families, but we've heard of complaints in Florida, Oregon, California. We've heard across the country. Next slide. And overall, this is the sentiment. All companies, family-owned as well as publicly owned, are required to make sure the products it sells are safe for consumption. Family-owned companies getting away with placing money and profits ahead of health and life, left unchecked, they grow into larger companies like Ford or Walmart. That's what happens.
Objection, Leosh.
Come approach. Ladies and gentlemen, that objection has been sustained, but you can continue with the rest of your argument.
Thank you, John. Let's go to the next slide, Shane. You remember this report. This is the FDA report, and this is Brent Jones, the president, who you heard from as the last witness that Real Water brought on. It's actually describing this company. Go to the next page. This description tells you how complex and complicated this business was, that Real Water was. They had a filing with the Wyoming Secretary of State in 2018 actually. The firm was previously located in Desert Inn. We know about that location. We also know that there was an establishment inspection report for the Mesa location. We know that there was a actual complaint related to a Tennessee location. That was from Ms. Kessler, who you heard from early on in this trial.
Objection, Your Honor, may I approach? Sure.
Take that down for a moment.
And you recall that Ms. Kessler, she testified earlier in this case. And she continues to talk about the Arizona location, as I said before, and then the holding company that they have as well as the second manufacturing facility. This is not an uncomplicated company. Several locations, several inspection reports, holding companies and the like. Next page. Mr. Randolph testified to the number of distributors this company has. And you have to have this number of distributors, we guess, to be able to sell across the country. From Budweiser to United Natural Foods, Nevada Beverage, all of these are local, regional, and national distributors. And then look at the retailers and sellers. From Whole Foods to Costco to Albertsons to Winco, across the country. Next slide. And here are some of the additional places real water is being sold. Mr. Randolph testified that they were selling real water nationwide. And he also testified that virtually every state. That's how big real water was. That's how much impact real water had. Next slide. In addition, they had their own online sales promoted by Miss Universe, Miss USA, involved in the UFC, MMA, celebrity promotions, everywhere. I want you to consider what Mr. Rich just said. Mark Rich said this is an $85 billion industry. Can we go to slide 29, please? And he suggested using 85 billion as the industry size, certain numbers. Now, I'm just giving you, again, this is the jury's decision to make. 5% of 85 billion is $4.2 billion. 2% of 85 billion is $1.7 billion. When Mr. Rich gave his number, he said 2 billion. We're asking for less than that. We're asking for $1.7 billion. 2% of the overall industry to deter others from engaging in the same conduct or misconduct that real water engaged in. And we believe that's what's necessary to be impactful for that industry based upon Mr. Rich's expert opinion. Could you go to slide 33, please, Shane? Now, this is a jury instruction the court just read to you guys. And ladies and gentlemen, I want you to focus in on the reason behind punitive damages. It says the amount of punitive damage award is not to compensate the plaintiffs. That's the first thing I want you to understand. But then right after that it says for harm suffered, to not compensate plaintiffs for the harm suffered, because you've done that already. But what is reasonably necessary to punish and deter the defendant and others. The and others is a reference to, in this case, this bottled water industry.
Same objections before you.
And that's what's important. Because I want you to be mindful, if you're going to make an impact in this industry, it's got to be something that they will take notice to. Before we met, none of you have heard of real water. I don't believe anyone sitting here in this jury heard of real water or what impact it may have had on these families, at least not these families. We would like you to send a message in terms of deterrence to others, that will be a positive impact on this industry. I want you to consider that. You're going to hear from Mr. Odou, and I'll get another chance to speak to you and go over some of the additional issues I assume will be raised by Mr. Odou. But I want you to think about that in terms of what's reasonable and what's necessary to deter others from committing what you've seen and heard real water committed in this case. You want this?
Oh, I thought Eric was going to argue. No?
Oh, no.
Okay, thank you.
You want this?
Yeah, please. Sorry, Mr. Pepperman, we're informal around here.
No, that's fine.
Thank you, sir, very much appreciated. Ladies and gentlemen of the jury, good afternoon.
Good afternoon.
On behalf of Real Water, on behalf of the attorneys for Real Water, and on behalf of the plaintiffs insuring the court, thank you again for taking the time to render a verdict in this matter. You spent a lot of time rendering that verdict, and we appreciate the effort that you took. And it's clear to us, and one of our colleagues said this, is that the jury wanted to get it right, and we appreciate that. I want to talk about a few things first. I want to talk about the jury instruction, and in particular, Mr. Zamora, can you put up the jury instruction for me, please? Ms. Parker talked about this, but you know, there is no fixed amount. We totaled up your total verdict in this case, and attorneys hate to do math. But it looks like it's about $90 million roughly. You may know that already. And the amount of punitive damages that Mr. Parker just asked for is well in excess of 17 times that amount. And I'm going to talk about that in a minute. And again, the verdict that you've rendered, the compensatory damages verdict, the $90 million, was without passion or prejudice and in accordance with the principles of law. You took your time, you wanted to get it right. Juries want to do the right thing, and juries do the right thing. And that's all that the parties ever asked for. It's all the lawyers ever asked for. And the amount of harm to the plaintiffs, and Mr. Parker said something interesting, and maybe I wrote it down wrong. But he talked about Real Water trying to excuse the harm they have done to the plaintiffs because of the size of Real Water. That was never one of our arguments. You saw us, Real Water, attempt to gently cross-examine these parents, and we never minimized, and still do not minimize, the harm that was inflicted upon them and the damage done to them and their children. Plaintiffs like to put words in our mouth. We like to use our own words, and the jury has heard us, and we appreciate that. And I'll be very candid, we've heard you. We've heard your verdict, and we think that your verdict is a fair one, and that you should use your verdict as the yardstick. I said it, I think, during voir dire, I said it during opening statement, said it in closing statement, I'll say it again. The arguments of counsel, the arguments that I'm making, and the arguments Mr. Pepperman may make, the arguments Mr. Parker has made, are just that. They're arguments. They're not evidence before you. You've heard the evidence, you've made your decisions, and you will continue to make the decisions. This is completely up to you. The reprehensibility of the conduct of the subject defendant, I think at this point, that much is not in dispute. You have found that their conduct was reprehensible and that it injured these plaintiffs. Now the question is punitive damages, and we think that you're going to arrive at a fair number. The second one, which I can't quite read, there we go, serve the purposes of punishment and deterrence. Now, you've just heard plaintiffs ask you to punish Coca-Cola, Nestle, Pepsi, these companies that are multi-billion
I'm sorry,
dollar
Your Honor.
companies.
Maybe approach.
Sure. Continue, Mr. Odou.
So I asked Mr. Rich the question that I don't know the answer to. That's, I guess, a cardinal sin of lawyers. You're supposed to know the answers to everything. Big secret, we don't. How many employees does Coca-Cola have? How many employees does Pepsi have? How many employees does Nestle have? I don't know, a lot. Real Water has locally about 30 employees. Mr. Zamora, can you pull up the Exhibit 2011 page? We'll scroll down. If you just go slow, I'll tell you where to stop. Okay, so the first page, obviously this is from 2019. This isn't current, but this is at the time of the re-audit. And I had the re-audit because I think the re-audit goes to the reprehensibility of Real Water. Real Water was trying to get it right. They didn't get it right. These plaintiffs got sick. And that's not what we were ever arguing. We're just trying to show you that they were trying to get it right because that goes to the reprehensibility. If we scroll down, we'll see, they fixed their HACCP problem. Let's scroll down some more. As we talked about, a number of people at Real Water wore a number of hats. They showed the facility audited. Let's scroll down a little bit more. Let's go to the next page at the top. There we go. So this is just one facility. So Mr. Parker can talk about the other facilities, but 30 employees. This is the 5-gallon line that, actually this is Desert Inn, so this is making both 5-gallon and retail at this time. The operations were later split. And retail, the 5 milliliter and 1 liter bottles were made in Arizona, and the 5-gallon was made here. But and that's a very big generalization on my part. Mr. Parker, if he wants to break that down further, I have no objection. But it's for my purposes. The point that we make is if you're trying to send a message to Coca-Cola, Pepsi, or Nestle, that's one thing. If the issue is the deterrence to Real Water and the punishment factor caused by the harm of Real Water and the size of Real Water. Now, $1.7 billion is a large number. And like I said, I didn't do the total math. Attorneys don't do that. 17 times your verdict. I would submit to you that's not a good number. I would submit to you that's an excessive number. We looked at a few things to try and give the jury, an idea of how much $1 billion is. But, let me start with $1 million. How big is $1 million? We throw around $1 million all the time. The average American drives 13,000 miles a year. I don't know if that's a Nevada person. I feel like we drive more. 13,000 miles a year, it would take you 76 years to reach $1 million. Okay, that's driving. That's not money, but it's driving. Truck drivers, they drive more than the average person. It takes you about 8 years to reach $1 million. $1 billion is 1,000 million dollars. So you take those numbers and you times 1,000 to get to $1 billion. Put it another way, the population of the United States is roughly 333 million and a third. If a rich person, pick your favorite rich person. I won't pick names because that implies politics. Pick your favorite rich person as a billionaire. If you gave $1 billion to everybody in the United States collectively, that's about $3 each. Maybe not that impressive. In Nevada, we have 3.178 million. So if that billionaire gives $1 billion to the people of Nevada, hey, now it's $314 each. That's starting to sound pretty good to me. All right, well, what if you wanted to travel, 1 billion miles? Well, we have something that's traveled about 1 billion miles. It's the Cassini spacecraft. It's out past Saturn. And we look like a speck of dust in the picture. You can see us and the moon. They just published that picture recently. What if you wanted to spend $1 billion? Well, if you had $1 billion and you spent $1,000 a day, you know? In a year, you spent $365,000, right? In 3 years, you spent about $1 million. So how long to get to $1 billion? 2,740 years. It's a long time to spend $1,000 a day. One more, and this one I found was very interesting. What was going on 1 billion hours ago? Right? Kind of a strange one. The Stone Age, that's what was going on 1 billion hours ago. All right, so 1 billion is a big number. 1.7 is a very much larger number. So what is the right number? Unfortunately, that's why we have to, you're gonna come to the right number. We would suggest that you use the verdict that you've already reached, the $90 million, and start there, and go with the number. You know, is it that number times 1, that number times 2, that number times 3? Plaintiffs made a fairly large, compelling argument about the number of months before the recall. I think they said 5 months. Is it that compensatory verdict times 5? There are a lot of different ways for you to arrive at a number that's fair and just. And we would ask the jury to just do that. You've already been working hard. We apologize again for asking you to do a little bit more hard work, but we are at the finish line. Thank you so much.
Any rebuttal argument?
Yes, sir.
Do it, Mike.
Yes, please. Good afternoon, ladies and gentlemen.
Good afternoon.
I have not had the opportunity to address you directly very often, so I just want to start by taking this opportunity to express my sincere gratitude for your time, attention, and consideration throughout this process. It's all that we could ever ask, and you have all delivered that, and we notice that, we know it, we know it's not easy, and on behalf of myself and all our clients here and the other attorneys, I just want to once again express our sincere gratitude for that. So we're in the home stretch. I'm going to speak to you for just a short period of time, and then Mr. Parker will finish it up, and then it'll be back in your hands. The purpose of this is to respond to what Mr. Odou just explained. Now, Mr. Odou suggested to you that there's no need for significant punitive damages because the lesson has been learned. But there is uncontradicted evidence in this case that the lesson has not been learned. And I'm going to start with the jury instruction because I think that's the best way to focus us. And specifically, the jury instruction focuses on deterring others. Now, Mr. Parker will discuss in detail with you a little more about the bottled water industry in general, but I want to focus on the primary trade group. Shane, can we have the next slide? Now, you remember in the trial, you heard from Mrs. Olson. Mrs. Olson explained to you a little bit about the International Bottled Water Association. I'm going to refer to it as the IBWA. The IBWA was formed in 1980. It's the leading trade group on bottled water, and it sets the standards in the industry. Ms. Olson is on the board of directors of that group, and Ms. Olson knows the facts of this case because she was retained as an expert, including that one person died and numerous people got acute liver failure because there was hydrazine in real water. Now, despite this, Ms. Olson does not believe that there should be non-targeted screening tests like a $100 GCMS test whenever a company brings a new bottled water product to the market. And despite the facts in this case, Ms. Olson explained to you that the IBWA does not recommend non-targeted screening tests like the GCMS test when a company brings a new bottled water product to the to the market. Sorry. Mr. Odou, when he was talking to you, discussed the evidence in the case, and I think that's an important statement because that's what I would like you to focus on, the evidence. If you recall from the evidence, Ms. Olson explained the prominent role of the IBWA.
And I also understand you're a board member of IBWA. What is that?
IBWA is the International Bottled Water Association. They were formed in the early 1980s, basically to have an industry group, an international industry group that represents bottled water and the standards that they adhere to.
Focus on this evidence. The IBWA sets the standards in the industry. The IBWA sets the standards in the industry. Because Ms. Olson explained to you that the bottled water industry refuses to do non-targeted screening tests like the $100 GCMS test when a bottled water manufacturer introduces a new product to the market. Shane, could you remind me?
Is non-targeted GCMS testing done in the bottled water industry?
No, it is not, and not without reason.
Despite knowing about the facts of this case, Ms. Olson said that non-targeted screening was not necessary unless there is a suspicion of a problem. I'm going to remind you of that testimony.
Okay, well, I thought you gave an opinion, and I can read it word for word for you, but in general, you said it was your opinion that you do the non-targeted GCMS only when you have reason to suspect an unknown substance. That's your opinion, right?
Correct, yes.
In other words, let's wait till after the problem. Let's wait till after people get sick or die before we do these tests. And again, despite the facts of this case, Ms. Olson told you that the IBWA does not recommend that the new bottled water plants have a standard where they do non-targeted screenings before they introduce a new product to the market. Let me remind you of that testimony.
Okay. Does the International Bottled Water Association recommend non-targeted GPS testing for bottled water?
They do not recommend it, no.
Ladies and gentlemen, this is the evidence that Mr. Odou was telling you about. This is the evidence. And history repeats itself unless someone forces a change. And I will respectfully submit to you that you, the jury, are that someone in this case.
Objection, Your Honor, may we approach? Sure.
Again, I will submit to you that you, the jury, are that someone, and that the IBWA and other key figures in the bottling water industry, like Mrs. Olson, are some of the others in the jury instruction. And I will also submit to you that your verdict needs to be a clear message that all bottled water manufacturers should spend $100 to do a non-targeted screening, like a GCMS test, when they bring a new bottled water product to the market. And that your verdict needs to be a clear message to the IBWA that they should change their recommendations and demand that all bottled water manufacturers spend $100 to do a GCMS non-targeted screening test every time they bring a new bottled water product to the market or open a new bottled water plant. If this message is not said and understood, I will submit to you that this will happen again. Maybe different babies that are hurt, but if bottled water manufacturers in the industry are not forced to know exactly what is in their bottled water product, there will be potential toxins in the future that go undiscovered. Now, you have the power to affect change, to make knowing what
exactly as in our bottled water product, the standard before people get sick or die.
Same objection, Mayor. Overruled.
Now, $1.7 billion is a big number. But we're asking you to send a big message. Mr. Kemp, the other day in his closing arguments, I think summed it up perfectly. This didn't have to happen. This shouldn't have happened. Now, we can't go back in time and undo what's already been done. But with your verdict, we're asking you to send a message so something like this never happens again. Thank you. Last time, ladies and gentlemen. I want to start off where Mr. Odou ended his closing yesterday, well, 2 days ago. Shane, if you could, I want you to consider what the president of Real Water said during a deposition, because we know he didn't show up here personally. I want you to hear what he said yesterday, Wednesday, actually.
What I'm going to do now is I'm going to leave you with the last piece of evidence that you heard. Just going to remind you of that evidence. And I want to play a short piece of Wren Jones' testimony as to what he knew and when did he know it.
All right, did you do any investigation into what went wrong when people got, first of all, let me do this. Are you aware of an association between consuming real water 5-gallon jugs in the fall of 2020 and liver injuries?
So I'll just, so we can cut to the chase, I think, I'll answer, I think what you're asking me. And if it isn't, you can get me to clarify. We had no idea that I had no idea that our water was causing problems. My own son Blaine got very sick, and at the same time, we didn't stop drinking raw water. We didn't have any idea that it was associated with raw water whatsoever. I mean, he got sick himself. And if we would have thought it was raw water, we would have done something at that time. We didn't because we didn't know there was any association whatsoever with real water. So no, I did not think that there was any problem with real water in October and November of 2020. I was completely blindsided when it happened in March.
And that's March of 2021.
I want you to consider that. The president has just said to us that he did not know, he was blindsided, he knew his son got sick, and yet never suspected the water. I want you to consider that testimony against the testimony of Anthony Randolph, the person who spoke to his son in October of 2020. Could you go to Randolph's testimony, please? Slide 17, I believe.
So then, you at some time form an opinion that the only similarity between these people would be real water.
Yeah, when I had a conversation with the owner's son, because I knew he was, became very ill, and it probably was in October, and I thought it was COVID, and they just didn't want anybody to know. But when my nephew and then another friend got sick, and then the phone calls that these guys were receiving in the office, then I asked the owner's son, his name was Blaine, I just said, I need to talk to you on a personal level. I know you were sick, can you tell me what happened? And he started describing everything that was going on, and it was identical to what my nephew and my brother, my best friend was experiencing. And so at that point, I told Blaine, I said, it's the water. I said, because the only thing that you guys have in common is you drink the water. Because even though my brother-in-law's best friend, comes around the family all the time, but he and my nephew don't really you know, they don't jive like that, you know, they're different age group, everything else. So at that point, I told Blaine, I said, you know, you gotta do a recall, man, there's something in the water. And that was probably beginning of November, something like that, middle of November or whatever it was.
And so you were forthright enough to come to Blaine, man to man, and I guess employee or sort of employee to vice president, he was the owner's son, and had this conversation in conference.
I did.
And at this point, you're laying it on the line. You got it. And you have the epiphany. You have the realization that real water is the constant between all of these people.
I did.
And you tell him it is the water that's causing these sicknesses.
I did.
Did you tell him that your nephew was hospitalized?
I did.
Did you tell him that your brother-in-law's best friend was hospitalized?
I did.
Did he confide in you that he'd been hospitalized?
He did.
And despite all of that, along with the customer complaints you became aware of, let me stop right there. Did you inform him that you heard through your conversations with the employees at the Henderson location that customers were calling sick?
I did.
So you laid that all on the table for him?
I did.
And you gave him the opportunity to be reasonable by presenting him with the recall suggestion?
That was just my suggestion, yes.
And what did he say?
He said no, because I first thought it was the water, but then I trying to remember everything that he said, trying to justify that it wasn't the water, and then I just told him, I said, Blaine, listen, we're getting numerous phone calls, according to, I think the gentleman's name was Anthony as well. They're fielding so many phone calls of people complaining. I know people that got sick. You were sick. You guys don't know each other. So it has to be the water.
Yes.
And he just, I traced it back. It's not that many. He just kept trying to justify it. So I just left it alone. I thought I did my part and brought it up and went from there.
So you, not only after having the first conversation requesting a recall, you had follow-up conversations with him, and you were using your words, numerous conversations, all the way into the beginning of the year, he still didn't do a recall.
Yeah, because we did talk about what reminded me, he didn't want me to go out and sell the concentrate itself. So we had conversations about, obviously, the problems that were going on, as well as how could we do something going forward.
So let's think about this. You're having your nephew get sick, the best friend of your brother-in-law, people that you're hearing about through the operations at Henderson, and despite all of that, including him getting sick, Mr. Jones getting sick, he's still trying to push the concentrate.
Yes.
In the beginning of this case, I asked, and I said this in opening, if this group, if each of you were prepared to make a difference. Mr. Pepperman just spoke to you about the consequences of not making a difference, and there's some more I'm going to show you. But certainly this gives you some insight into the mindset of real water. When the president can say under oath that he knew nothing about this, and you see the vice president of sales and distribution going to his son after his son gets out of the hospital, and he thinks so little about the safety of others that he would put money ahead of health, ahead of life. Let me show you the consequences of their complete indifference to the health and safety of these plaintiffs. Could you go to slide 25, please? And this is all from the FDA documentation that you've seen. We know one death, 2 children with biopsies just in this, from these plaintiffs. 8 plaintiffs in this case you're aware of. 4 biopsies in Loma Linda. 20 to 25 reported customer complaints found by the FDA. 23 customer delivery terminations caused by medical illnesses. 3 dead dogs, dead cat. 14 customer complaints and evidence that we brought before you, not including Mr. Randolph's nephew and his brother-in-law's best friend. Just that you've learned in this case Next slide. You've gotten medical testimony, undisputed at this point, of that all plaintiffs suffered permanent liver injuries. And you've made decisions on that. You've got undisputed medical testimony on future medical monitoring, undisputed testimony on neuropsychological monitoring, and you've learned that Mr. Tagano's recent abnormal liver function test has compromised his longevity and health with his wife and his family. These are the consequences of not making a difference. Next slide. Go right ahead. This is the reason behind, no, you're right there. This is the reason. Now that's 2011, Mr. Rich has given us up-to-date information. Go to slide 30. This is what Real Water wants you to do. This is the crux of the matter in terms of what they're suggesting to you monetarily. And we've all heard of this. Hope for the best, but prepare for the worst. During the compensatory stage, Real Water suggested a number that was based upon everything going right in the rest of the lives of these plaintiffs. That's what they were telling you. Oh, they're gonna be fine. They're fine, don't worry about it. That's what they were asking you to provide, compensatory damages based on them being fine. All the plaintiffs going back to their lives with no other problems. Completely asking you to ignore the evidence in this case. We asked you in the compensatory phase to prepare them for the worst. And now, next slide. In this phase, Real Water is saying, let's find the lowest number. Let's just multiply it by 5. Find the lowest number that we can accept, which in their opinion is $465 million, which is not even a fraction of 1%. I guess it's half of 1%. 1% would be 850 million. They're asking you for 1/2 of 1%. That's going to send a message to the $85 billion industry. We're asking you at even less than at 2% to send a message that would be impactful, positively impactful. And that's why you cannot base your punitive damage amount on hoping for the best. You have to base your decision on what does it take to make a difference. What does it take to impact this industry? And we're just saying 2%. Shane, can you show that figure I gave you a little while ago? I want to give you an understanding of where these numbers play out between Real Water suggestion and what we've suggested. So we've suggested 1.7 billion, which is, like I said, 2% of this $85 billion industry. Real Water suggested 465 million, which is 1/2 of 1%. That's the middle point. The middle point between these two numbers is $1,082,500,000. Now, we're not asking you to come to the middle, but we wanted to show it to you, to see what it looks like. Again, this is not an award to compensate the plaintiffs. This is an award to deter others. What I also want this jury to consider is what happens if you don't send a message. If you could go to slide 21. If you don't send a significant punitive damage award message, what you're saying to the industry is, it's okay to create a new product or a new manufacturing process without testing. That's what you're telling them. Don't worry about testing. Don't worry about whether or not the manner of processing is safe. Don't even worry about if the product is safe. Just put it on the market. Start making money. Next. It's okay not to conduct non-targeted screening. That's what you're saying. Next. And you put them all up, Shane. We'll take them quickly. It's okay not to investigate customer complaints. It's fine not to test the safety of your product after your customers have reported health problems. It's all right not to have a qualified QA, quality assurance, or a quality control employee, like Frito-Lay has. You know, that's what you're saying. It's saying it's okay to not stop production, even when your employees say, stop the line. Even when your vice president says, do a recall. No, the sentiment from Real Water was, you keep that line going. You keep those trucks going. That's what this Dissatel said, this Converse said. If somebody complains, give them some more free water. Give them some more poison. That's what you're telling them. Next slide. It's okay to refuse to cooperate with the FDA, the CDC, and the Southern Nevada Health District. You're giving them a license to say, you don't have to come to the inspections. You don't have to answer questions of the investigator who's trying to figure out how to protect the public. You can refuse to reveal information regarding the secret concentrate room, or how this product is being made by electrifying titanium tubes. You can refuse to provide requested documents. You can hide behind your lawyer. Next. It's okay to violate the FTC Act by providing an adulterated product, which we know is an unsafe, filthy product. In this case, a poisonous product. Next. It's okay to violate 21 CFR 117, which is good manufacturing practices, which Dr. Hutt spoke about. And it's okay not to test a product as required and fail to maintain records of testing. That's what you're saying if you don't give a significant punitive damage. Ladies and gentlemen, I've tried several cases, and I've asked many juries to make a difference by returning large or significant decisions and awards. This is the first time I've ever asked a jury to make history.
Objection, Your Honor.
Sustained. Rephrase.
Sure. This is the first time I've asked a jury, considering this evidence.
Yeah, so come approach.
I've asked you to make a difference, now I'm asking you to make history. I want you to send a message that prevents this type of history from happening again. And that's why I say, not just a difference, but history. And I know you all have it in you to do so. You wouldn't be here if you weren't. Anyway, I ask that you consider all of the evidence. I ask that you consider how impactful this decision has to be to change what's going on in this industry. And with that, I thank you for all your time, all your effort, and all your patience. Thank you very much.
Okay, ladies and gentlemen, I'll ask that you all accompany real life, ladies and
Can I
gentlemen.
ask a question? No?
If you write it down.
I wrote it.
Okay.
Okay.
Question will not be answered.
Okay. I thought it might not be on.
So if you all could accompany Marshal Walker back to deliberate in the jury room. Watch your head.
And you've been telling everybody.
Yeah. Watch your head.
Back to the jury.
Let's see, anything we need to discuss? And you all can stay in here if you'd like.
Much appreciated, Your Honor.
Let's walk through them. I'll ask to meet with them after. I'll invite you all. What's limited? You know,
Judge, usually we just talk to them about the elevators, if they want to talk.
if you want to talk to them in the jury room after, 2 from each side. If you do that, what I do not want to see, I had this happen once, so this is why I say that, is I don't want an attorney's affidavit from their conversations. If you do go back, then they do choose to talk to you, that's off the record. It's not for you to file some type of post-trial motion for like fees or something like that and say, oh, a juror told me this or that. I was not happy when that happened. So there's that. Some of them may stay, some may not.
Sounds good, John. Thank
Thank you,
you.
Your Honor.
Thank you.
I kind of run a snapshot because you're killing that, yeah. You're still too
Please rise for the jury. Please be seated.
Welcome back, ladies and gentlemen. Stoddard, you're still the foreperson?
I still am.
Have at least 3/4, or 6 out of the 8 jurors agreed
It
upon
was
it?
unanimous, Your Honor.
Thank you. Please give that to Marshal Fokker. The clerk will now read the verdict out loud.
District Court, Clark County, Nevada, case A-21-831-169B. Christopher Noah Wren, a minor child by through his parents Christopher Brian Wren and Emily Wren, husband and wife. Christopher Brian Wren on his own behalf, Emily Wren on her own behalf, Kara Carrier, a minor child by and through her parents Ryan Carrier and Erica Carrier, husband and wife. Lyric Williams, a minor child, and London Williams, a minor child, by and through their mother, Shantae Williams. Severin Morales, a minor child, by and through his father, Jorge Morales. Joseph Tagano, an individual, versus AffinityLifestyles.com Inc., doing business as Rowater, a Nevada corporation, Rowater Inc., a Delaware corporation. We, the jury, return the following verdict. Punitive damages are awarded against Rowater in the following amount: $3 billion, dated this 14th day of June 2024. Mary Stoddard, jury foreperson. Ladies and gentlemen of the jury, is this your verdict as read?
Yes.
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 Thank you. Do either of the parties desire to have the jury poll?
No, Your Honor.
No, Your Honor.
No, Your Honor.
Thank you. The clerk will now record the verdict in the minutes of the court. Ladies and gentlemen, I want to thank you all very, very much. You're now discharged from your service, so I don't have to read that instruction to you again. You are welcome to talk to whomever you would like to. You're welcome to not talk to anybody. What I would like to do is meet with you to thank you personally in the jury room. The attorneys may also want to talk to you after. I'll talk to you a little bit about that when we go back. Thank you all again very much.
Please rise for the jury.
Before I go back there, I want to thank all of you for putting on an excellent trial. It's been a privilege to preside. So I'll go back there right now, figure out who, two from each side. Anything else or any questions?
No, Your Honor. Thank you.
Thank you.
Thank you, your staff.
Thank you so much.
Will be honored.
No further.